Today on the Daily Dose, checks and balances. Building on the ideas of ancient Greek statesman Polybius, Enlightenment thinkers Baron de Montesquieu, John Locke, and 18th century British jurist William Blackstone, the framers of the U.S. Constitution divided both powers and responsibilities of the new federal government amongst three separate branches, known collectively as legislative, executive, and judicial branches of governance. If men were angels, James Madison wrote in the Federalist Papers, no government would be necessary. In framing a government which is to be administered by men over men, the great difficulty is this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. Known as checks and balances, the Founding Fathers injected numerous combinations into the U.S. Constitution, including the President or head of the executive branch, who serves as Commander-in-Chief of all American armed forces, while at the same time, Congress or the legislative branch appropriates all funding for the military, as well as maintaining sole voting power to declare war or ratify peace treaties. Within the legislative branch, each House of Congress checks any possible overreach by the other, requiring both the House of Representatives and the Senate to pass a bill in the same form before it becomes passed into law. And while the President has the power to veto specific pieces of legislation sent to him by the executive branch, Congress can override the President by a 2/3 majority vote, so long as both houses vote for the same outcome. In an effort to check both the executive and legislative branches from unequal or unilateral power, the judicial branch, made up of the Supreme Court and other federal courts, can declare laws or presidential actions unconstitutional, while Congress, by passing amendments to the Constitution, can effectively overturn the decisions by the judicial branch. The President, in turn, can reshape the conservative or liberal leanings of the judicial branch, particularly the Supreme Court, by appointing judges closest to the President's political leaning when a Chief Justice resigns or passes away while still in office, making the system of checks and balances one of the most fundamental underpinnings of American democracy. Marbury v. Madison. In a case of blatant court packing, 2 months before incoming President Thomas Jefferson was slated to take office, outgoing President John Adams asked his Secretary of State and close advisor John Marshall to fill a vacant seat on the U.S. Supreme Court after Chief Justice Oliver Ellsworth stepped down over health concerns. While such important dual roles in American governance would be seen as a serious conflict of interest in today's world, a week after his nomination by Adams, the U.S. Senate unanimously confirmed Marshall's appointment to the top spot on the Supreme Court, followed by more political court packing when Adams nominated 42 men to serve as justices of the peace just 1 day before Jefferson's inauguration. Unable to juggle the demands of both jobs effectively, Marshall left 4 commissions unfulfilled, including one belonging to Virginia politician William Marbury. When Jefferson took office, the enraged president instructed his new Secretary of State James Madison to withhold all 4 undelivered commissions. At a time when the power of the Supreme Court had yet to be fully defined, Marbury bypassed the lower courts by petitioning the nation's highest court for a writ of mandamus, which is a court decree ordering government officials to properly complete their unfulfilled duties. Lacking even a building of its own, on February 10, 1803, the Supreme Court convened in a basement room in the U.S. Capitol, where Attorney General Levi Lincoln Sr. represented the Jefferson administration, while outgoing Attorney General Charles Lee advocated for Marbury, both sides attempting to flesh out 3 primary questions. Did Marbury and the other judges have a right to their commissions? Had their rights been violated? And did the U.S. Supreme Court have the right and authority to remedy the problem? Drawing from portions of the Judicial Act of 1789, the Supreme Court's decision, penned by Marshall himself, found that Marbury's rights had been violated by Jefferson, despite the fact that all four men had been confirmed and affixed with seals, further affirming that Marbury had the right to sue and seek legal remedy in court, while a federal judge had the power to issue a writ ordering Jefferson to comply with the court's decision. The court's ruling was immediately recognized by a young nation as a fundamental moment in American jurisprudence, establishing the Supreme Court's authority over other branches of government in its power to interpret national and constitutional laws, making Marbury v. Madison an undisputed turning point in the authority of federal courts. Mccullough v. Maryland. In 1791, after Treasury Secretary Alexander Hamilton called for a strong central bank to stabilize a young nation's economy, Hamilton's proposal faced stiff opposition by Thomas Jefferson and other anti-federalist legislators, who feared that a federally controlled bank would undermine the stability of state banks. Despite Jefferson's objections, President George Washington signed the Bank Bill of 1791, which soon witnessed the opening of federal banks in Philadelphia and 8 other large American cities. The bank's charter would lapse in 1811, yet after federal debt rose precipitously during the War of 1812, Congress chartered the Second Bank of the United States in 1816. 2 years later, after Maryland legislators imposed a stamp tax on currency issued by the Second Bank of the United States in an attempt to limit the bank's authority, when Baltimore branch cashier James W. Mccullough refused to pay the tax, the issue made its way through the American court system until it reached the Supreme Court on appeal. Presiding over the then 7-member Supreme Court was Chief Justice John Marshall, who heard arguments surrounding the case on February 22, 1819, in a courtroom in the basement of the U.S. Capitol. Representing Maryland was high-powered attorney Luther Martin, who had famously walked out of the Constitutional Convention of 1787 to voice his opposition to the creation of a strong central government, while statesman and attorney Daniel Webster spoke on behalf of the bank. Citing the 10th Amendment, which states that any power that the Constitution hasn't granted to the federal government or limited the states from using is either reserved for the states or the American people, Martin argued that the Constitution gave no authority to Congress regarding the creation of a bank, while Webster cited Article 1, Section 8 of the Constitution, which granted Congress power to make all laws which shall be necessary and proper, which Webster argued was necessary and proper to levy and collect taxes, borrow money, pay for the military, and regulate commerce. Ultimately, the court ruled in favor of Mccullough and the Second Bank of the United States, while many constitutional scholars believe the Supreme Court's ruling on Mccullough v. Maryland opened the floodgates for what some have labeled an administrative state, which, as the nation grew in population and wealth, witnessed a steady rise in federal oversight regarding all aspects of American life, paving the way for Roosevelt's New Deal reforms of the 1930s and the creation of the Social Security Administration, the passage of the Civil Rights Act of 1964, and the Patient Protection and Affordable Care Act of 2010, making Mccullough v. Maryland a lasting big win for centralized government in America. The Connecticut Compromise. After Britain's 1781 surrender at Yorktown, by 1786, it became increasingly apparent that the Articles of Confederation would prove insufficient to govern a young nation. In response, on May 25, 1787, delegates representing every state except Rhode Island convened at Philadelphia, crafting a government model of checks and balances that nearly derailed over the issue of equal representation. At issue were disparities in state populations, prompting high population states to argue that representation in Congress should be proportional to a state's population, while smaller states with lower populations demanded equal representation in Congress. Known alternatively as the Great Compromise of 1787 or the Sherman Compromise, the Connecticut Compromise was first proposed by Connecticut delegates Roger Sherman and Oliver Ellsworth, which, when agreed upon, established two bicameral legislatures in Congress, with the number of members elected to the House of Representatives based on a state's total population, while members of the Senate ensured equal representation in all states by electing 2 senators per state, regardless of a given state's population. The original plan obliged state legislators to choose their senators, while the 1913 17th Amendment to the Constitution handed senatorial election power to the people. Approved by a narrow margin on July 23, 1787, as the United States grew in population and demographics over the coming years, however, the Connecticut Compromise inadvertently handed states with smaller populations a disproportionately larger voice in Congress, giving least populated states like Wyoming an advantage over much larger states like California, which touts a population some 68 times greater than Wyoming's, allowing smaller states to capture disproportionate attention and federal funding, such as hog farming in Iowa or mining interests in West Virginia. It also has drifted from the Founding Fathers' original thinking within the Electoral College used in the election of presidents, since the number of electoral votes designated to a state based on a state's combined number of representatives in both chambers of Congress, lending further power bias to smaller states over larger ones. Despite these disparities of power, the Great Compromise remains protected by Article 5 of the Constitution, which maintains that no state can lose its equal representation in the Senate without that state's permission, making the Connecticut Compromise an unequal yet lasting part of constitutional law. The Constitutional Convention of 1787. Ratified several months before Britain's 1781 surrender at Yorktown, the Articles of Confederation provided a loose framework for federal authority. But since the document gave Congress no rule to demand money or troops from individual states, by 1786, it became increasingly apparent that without a stronger document, the young nation would soon splinter and fail. In response, on May 25, 1787, delegates representing every state except Rhode Island convened in Philadelphia at what is now known as Independence Hall, where Virginia war hero George Washington was quickly elected convention president. Over the next 3 months, the delegates landed upon a brilliant federal system of checks and balances, and when the delegates from smaller states divided over the issue of equal representation in Congress, the problem was resolved by the Connecticut Compromise, which proposed a bicameral or dual legislature made up of the lower house or House of Representatives that offered proportional representation based on total population, while the upper house or Senate answered the delegates' call for equal representation. As a result, on September 17, 1787, the Constitution of the United States of America was signed by 38 of 41 delegates, although the document would not become fully binding until 9 out of 13 states had signed. Some states, particularly Massachusetts, opposed the documents on the grounds that it lacked constitutional protections such as freedom of speech, religion, and press, leading to a compromise agreement ratified by the dissenting states, provided certain amendments could be added to the U.S. Constitution shortly after its ratification. On September 25, 1789, the first Congress of the United States adopted the first 12 amendments to the U.S. Constitution, collectively known as the Bill of Rights, except for holdout Rhode Island, who opposed federal control of currency. Their objections dissolved after the federal government threatened to sever commercial relations with the state, leading to full ratification on May 29, 1790, making the U.S. Constitution the oldest national governing document operating in the world today. Today in the Daily Dose, the Federalist Papers. After the United States declared independence from Great Britain, the Articles of Confederation granted Congress power to engage in foreign policy while maintaining an army and coining money. But the newly formed centralized government lacked full authority over the individual states, including the inability to levy taxes or regulate commerce, which crippled the nation's ability to pay her war debts. Such deficiencies led to the Constitutional Convention of 1787, in turn producing the U.S. Constitution, which immediately caused furious debate between the Federalists, who favored ratification of the Constitution as written, and the Anti-Federalists, who opposed the creation of a strong central government. Anti-Federalist opposition was strongest in New York, leading New York lawyer and statesman Alexander Hamilton to team up with New Yorker John Jay and Virginian James Madison, penning 85 essays in support of the Constitution. To bypass any charges of betraying the Continental Convention's confidentiality rules, Hamilton used the pen name Publius after the general who helped found the Roman Republic, submitting Essay 1 for publication in the Independent Journal on October 27, 1787, where he raised the question of whether societies of men are really capable or not of establishing good government from reflection and choice, or whether they are forever destined to depend for their political constitutions on accident and force. Jay wrote the next 4 essays until he was forced to drop out due to an attack of rheumatism, later penning 1 more essay, which paled in comparison to Madison's 29 and Hamilton's staggering 51. In the Federalist Papers, the three patriots argued that without a centralized government, the United States would not be strong enough to compete on a world stage or quell homegrown insurrections like Shays' Rebellion. Federalist 10 would become the most influential essay of all, where Madison argued against French political philosopher Montesquieu's belief that a true democracy was only feasible for small states. Other essays emphasized the weakness inherent in the Articles of Confederation, while Hamilton wrote 14 essays on the importance of taxation, followed by 20 essays explaining the need for checks and balances between the 3 branches of government. While the Federalist Papers saw little circulation outside of New York at the time of their publication, they also failed to sway many New York voters from their anti-Federalist bent. Even so, in July of 1788, a slim majority of New York delegates voted in favor of the Constitution, on the condition that further amendments would follow in the Bill of Rights, making the Federalist Papers a unique insight into the thinking of the American forefathers. And there you have it, the Federalist Papers, today in the Daily Dose. Get your nerd on with the Daily Dose. And if you enjoyed today's episode, share the link with a friend or colleague so that they too can learn something new every day.